Me, Zarine. So today's topic is affidavit. Okay, so let's talk about affidavit. What is an affidavit? So an affidavit is a sworn statement backed by a person who knows that such facts and circumstances have taken place. The person who makes such statement and sign is known as deponent. An affidavit is a written document signed by the deponent confirming that the contents of the affidavit are true and correct to his knowledge, and he has concealed nothing material therefrom. It is duly attested affirmed by the Notary Oath Commissioner. Such notary oath commissioner are appointed by the court of law. The duty of the Notary Oath Commissioner is to ensure that the signature of the deponent are not forged. Hence, the deponent himself needs to be present before the Notary Oath Commissioner during the attestation of the affidavit. So now, the affidavit must be paragraphed and numbered. The person making the affidavit must sign the bottom of each page in the presence of an authorized person, such as lawyer. Further, the affidavit must contain the full name, address, occupation, and signature of the person making such affidavit and the date and place where such affidavit is made. The affidavit must contain fact and circumstance known to be person and must not set out the opinions and belief of the deponent. Further, one should avoid referring to facts that are based on information received from others, known as hearsay evidence. However, it is the person is giving evidence as an expert, for instance, a psychologist or licensed valuer, then his opinion might be stated in the affidavit. So now let's discuss affidavit as evidence under the Indian Evidence Act. So affidavit is treated as evidence within the meaning of Section 3 of the Evidence Act. However, in the matter of Khandesh, SPG and WBG Mills Co. Limited versus Rashtriya Girni Kamgar Sangh Citation 1960 AR 57-1, it was held by the Supreme Court that an affidavit can be used as evidence only if the court so ordered for sufficient reason, namely the right of the opposite party to have the deponent produced for cross-examination. Therefore, an affidavit cannot ordinarily be used as evidence in absence of the specific order of the court. Further, the law pertaining to affidavit is covered under Section 139 of Order of CPC. So, the court to order at any point of time any particular fact or fact to be proved by affidavit. But the court shall not make such order where it appears to the court that either party desires the production of witness for cross-examination and such that witness can be produced. So let's see one case of an affidavit. The Supreme Court in Amar Singh v. Union of India and others has issued directions to the court to carefully scrutinize all affidavits, petition and application and reject those which do not conform to the requirements of order of the CPC. The Supreme Court has highlighted the importance of affidavit in this judgment and has discussed various judicial pronouncements on the aspect. So what is the consequence of filing false affidavit? So a false affidavit is one in which a person deliberately swears false and frivolous statement to be true, correct and accurate in affidavit and sign it in order to deceive and mislead the court. This causes inordinate delay in proceeding and is a clear misuse of the judicial process. Filing of false affidavit is an offense of perjury under the provision of the Indian Penal Code. It is a criminal offence under Section 191, 93, 95 of IPC 1860 to make false affidavit in one's pleading or filing false affidavit or false document is evidence before court of law. Further, criminal contempt of court proceeding can be initiated against the person filing false affidavit. So, criminal proceeding may be initiated against the guilty of by making an application under Section 340, read Section 190 of CRPC before the criminal or civil court for giving false evidence. So, thank you.